you, Dr. Zimbardo. Our next speaker is Robert Cole, Professor Emeritus at Berkeley Law, and professor there since 1961, teaching constitutional law, ethics, and torts. Before coming to Berkeley Law, he clerked on the United States Supreme Court, maintained a private practice, and worked on national security matters as a lawyer in the Office of the Secretary of the Air Force during the Eisenhower administration. Dr. Cole has taught me the importance of legal counsel, or calming his client, and subsequently has become my friend. So please welcome Dr. Cole.
Thank you. You've heard about these torture memos from Deborah and from Phil, and I'm not going to go through them, but these were memos written in the Office of Legal Counsel, which is a very high-level office in the Justice Department, and one of its jobs was to give advice to the President about what could be done by way of forceful interrogation and prolonged detention. And what I want to talk about is why and how classical ethical considerations required certain constraints in the advice to the White House, or do require certain constraints to the White House on interrogation and detention. In other words, I'm going to say that outside ethics have to be brought to bear sometimes by lawyers giving advice. Now, when I say ethics, I'm not talking about the rules of professional conduct. I'm talking about classic philosophical ethics, but the points that I'm going to make are very straightforward and not particularly fancy. Now, few of us are going to be advising the White House. I'm sure some of you will, but most of you won't, probably. And the things I'm going to say, I think, are relevant not just to this high-level example, but are relevant, I think, whenever a lawyer is under a great deal of pressure. Time pressure and pressure from the client, and when the stakes are high. So I'm hoping that the law students here will at least consider these points for the future in your own practice. Now, because of our time, I'm just going to posit that torture, cruelty, coerced confessions, indefinite detention, basically forcefully using another person who's a captive for your purposes, violates the idea of personhood. And that idea of personhood, that there is something inviolable about each individual that nobody can take away, nobody's allowed to take away, must be respected. I think that's the starting premise of any ethical system that we would be using to discuss these issues with, including, in my own view, utilitarianism. And so I think that inviolable personhood is a premise of the ethical system. It's also a premise of the legal system. The common law system that you know, I think, posits an irreducible, free, equal, autonomous person as the fundamental starting unit of the whole system. And that's the basis you can think about it towards contracts procedure. So with that assumption, then let me give you two reasons, two clusters of reasons why, ethical reasons, why I think there is a duty to take account of the values of personhood in giving legal advice. I mean, needless to say, the values of personhood were not taken account of in the so-called torture memos. They are not even discussed. So one reason, one type of ethical reason that I think requires the lawyer at this level to take account of personhood in his advice is that you've got to avoid causing harm to your client, the president in this case, from your legal advice. And advice which could lead him to be susceptible to indictment as a war criminal, that could lead to terrific backlash in his ability to conduct the office, and could lead to very high costs in trying to, in some way, be accountable for these forceful methods of interrogation or detention. Those are all harms that could come to your client, and so you want the client to be informed before he makes a decision. And secondly, you want to make sure that the client has, that's the president, knows what the full range of options and risks are in what he is proposing or wants to, or is asking about doing. It's just like in informed consent in medical cases. In order for the patient to make an informed decision about how he or she is going to be treated, you've got to tell him or her what the risks are, what the positive benefits, what the downsides are. Well, you've got to do that in your legal advice, in my opinion, in order to, in a situation like this, to avoid causing harm to the client. The torture memos did not do that. They were completely one-sided, basically a kind of whitewashed advocacy argument as to why you could do what you said you want to do. So they took away those options. The second cluster of reasons why a lawyer has to include the values of personhood in the analysis has to do with the lawyer's ethical commitment to the legal system itself. If you justify your behavior on the grounds that the legal system produces overall good for society, and therefore it's okay for you to represent, lobby for tobacco companies, to represent polluters, to try to get drug dealers off and so on. If all those things are justified because the system is good, and that's our argument, that's what we believe, then you have to live up to the system's basic premises. In other words, you can't use the system as a justification for your behavior without then committing yourself to vindicate the premises of the system. And one of those, as I just said, is personhood. So you can't just ignore it if you're going to justify your behavior as a lawyer. Now, nobody can have perfect immunity in his personhood. We're controlled and restricted, and forces used on us all the time. The Fifth Amendment, the Fourth Amendment, things that I think the students here might be familiar with, defenses of self-defense, the defense of necessity, and blowing up somebody's property to prevent the spread of a fire and so on. These are all packages of considerations that take account of a variety of values and allow you in order to serve, say, values of safety and security and so on. You're allowed to interfere with other people. Nobody has total immunity. Your personhood as a series of choices isn't immune from any regulation, but we have instead a kind of a general consensus about how much force can be used on people under our laws and Constitution and under the common law, and how much can't. And those limits are light years away from the kind of things that, not just this Abu Ghraib, but the kinds of things that are done in rendition and in Gitmo and so on. Justice Frankfurter said that using a stomach pump to obtain drugs that the defendant had swallowed is like the rack and the screw. Just a stomach pump. A blood sample taken by a nurse to test your drunkenness for drunk driving prosecution was upheld by the Supreme Court under due process, but just barely, 5-4. In other words, that's as far as the law lets you go in intruding on people. This stuff is nothing like what we're talking about in these anti-terrorism programs.